From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Thank you so much for joining us. And we have someone special joining us today. Our executive producer. I almost gave you a demotion. Not really. No. Our executive producer, Jeff McLean, with us. Greg, always good to see you.
It's good to
We're
be
talking
here.
the NCAA, UT, and the NIL. Yesterday, we thought that was a big day. Today, we have even more when it comes to this. Yesterday, it was revealed the NCAA investigating Tennessee and a booster-funded NIL collective, Spire, which I want to point out, WATE has a partnership with.
Media partnership.
Today, a media partnership. Today, the Attorneys General of Tennessee and Virginia filed a lawsuit against the NCAA over all of this. So let's talk about where we are right now and what's to come.
Well,
Jeff, why don't you lay the groundwork?
Okay, well, first of all, I think it's important to understand that NIL comes out of a decision of almost 3 years ago from the Supreme Court. And this has been something that's been fought for a long, long time about what players... No one seems to want to pay players directly, but they also recognize that players earn money for the universities and in a lot of different ways. So this Alston decision was sort of kind of the best way they can reconcile this, and that's where NIL comes from, name, image, and likeness, which is to say that they can benefit from deals beyond the university that traffic in their name, image, or likeness. If they want to go and sign autographs, or if Joe's car dealership wants to have a quarterback say this is the best Ford you've ever bought, they can do that, and that way the athletes can earn a little bit of money. Whereas in years past, they've only been able to have scholarships and a few other little benefits connected with campus. But, as soon as you open the door to money in athletics, the floodgates are open.
So, Greg, let's talk about the legal aspects of this. And,
Right.
and Donde Plowman, the chancellor, is saying this whole thing is so vague anyway, and athletes deserve a right to have some benefits here.
Well, Chancellor Plowman has come out swinging, and she has gotten right to the heart of the matter. And, Jeff, when you say, allow amateur athletes to make a little bit of money, right out of the chute, starting with Texas A&M, they made big money.
That's true.
And
and
but Chancellor Plowman really identified some of the issues because the Supreme Court in the Alston decision in 2020 said that it was a violation of the Sherman Antitrust Act for universities to exploit amateur athletes for free or very little pay, such as per diems for clothing, food, and travel, and profit off their name, image, and likeness. So fast forward, the NCAA said, basically, you can profit from your name, image, likeness. And the way it was contemplated is you could allow a student to have an internship or be a spokesperson, but there had to be some quid pro quo for the money. But the NCAA, which is an administrative agency, never really defined what the rules were. So fast forward today, the state of Tennessee, in response to this investigation that was leaked by Sports Illustrated, and Virginia has filed a lawsuit alleging that the NCAA, a la Alston, once again is violating the Sherman Antitrust Act. And this is where it's going to get move really quick and get really dicey. They have filed it in federal court here in the Eastern District of Tennessee, and they're asking for a temporary restraining order and a permanent injunction.
What does that mean for people listening?
That means they are going before a federal judge, and they are asking the court to rule that the NCAA cannot investigate the University of Tennessee or anyone for these violations of NIL. And let's talk about the problem. The rules, which are basically regulations, memorandum, and guidelines, have been ever-changing since 2020. And to say they're ambiguous would be a tremendous understatement.
Let me jump in and read what Donde Plowman said about this, the chancellor, and then we're going to hear from her too. She said, and I'm quoting, "Instead, 2.5 years of vague and contradictory NCAA memos, emails, and guidance," she says, "about name, image, and likeness has created extraordinary chaos that student athletes and institutions are struggling to navigate." In short, she says, the NCAA is failing. Now, she was asked today, what is the support UT is getting from local and state politicians? Let's listen.
I'm not surprised. Everyone loves this university. This is the state's university. It belongs to the people of Tennessee. It's moving, and I really...
So yeah,
basically she said she's thrilled.
Yeah.
Everybody's supporting this side of it.
And I think that, that's an interesting something. It's interesting that Tennessee seems to be on the leading end of this because, and this is something we can go into a little bit in a second, but Tennessee just went through quite a big investigation focused on the activities of former coach Jeremy Pruitt and how that was managed by the university. And in that instance, the university made some real clear, bright line distinctions between here's us and here is Pruitt. And, instead of standing by their man, they said Pruitt's going to have to own up to what he did or didn't do. And in doing so, the university demonstrated, well, one, just some forthright straightforwardness.
Well, they were transparent. They're very transparent.
And then also the institutional controls issue. That's something that listen, we as an institution have controls to stop these violations from happening. We can't necessarily, put a rope around our guy and say he didn't do it, but don't punish us, punish him.
And the irony, the ultimate irony is what Pruitt did, pay athletes right before the Cade Mays transfer and whatever. Then it all, after Austin, suddenly became a moot point because you didn't need to put money in McDonald's bags and give to players. You signed, front page lucrative deals. But legally, here are two things that needs to be reconciled and is fundamentally flawed with the NCAA's position. When this first started in 2022 to show there was a violation of NIL, and here's the big picture. They're saying that you can't use NIL money as a recruiting tool to get someone to come to a particular institution. You can't go to a high school, like Nico was recruited out of California, and say, we are going to give you millions of dollars to come to Rocky Top. So think about the intellectual dishonesty about this. So you got a collective, you go sign him up, and then you say, we don't care where you go, and you're the athlete, and you're not going to know you're going to get any money till you get, whether it's the University of Tennessee or the University of Goose Pimple Junction. Makes no sense.
Where is that,
right,
Greg?
But your $8 million contract, allegedly, is coming from a Tennessee-based group that supports Tennessee athletics.
Follow
Correct.
the money. And so the other thing that is interesting, at the beginning, for a school to violate this inducement prohibition, there had to be clear and contrary evidence that there was an inducement. Well, so then fast forward to 2023, a year later, then we can now have an investigation and find that you violated the policy by only circumstantial evidence. Think about this. If you're a lawyer, your head is spinning. Clear and convincing is one of the highest standards there are legally, and the current burden of proof is circumstantial evidence. I don't even know, and when Chancellor Plowman said this is chaotic, that was the biggest understatement that we've heard so far. What is circumstantial evidence? To me, that means no direct evidence of any wrongdoing by the University of Tennessee.
And this is a big, bold statement from her.
Yeah.
I mean, the NCAA is obviously a big, powerful organization, and she was asked today, why did you decide to take this fight?
Someone charges you or your family or your children with something that you didn't do and you think is unfair, you're going to speak up. And so that's kind of how I feel. Was sort of no question in my mind about what to do. And I made that clear in the letter. And when you're leading in university and someone attacks you and makes an allegation that isn't true, I will always respond. And the most significant thing about that is I will always stand up for our student athletes. And that's where the attack was really on, if you want to be honest about it. And so it won't be the last time I stand up for student athletes.
All right, there you go. Yeah, let's underscore that so that this won't be the last time I stand up for student athletes.
And that's something I wanted to highlight because there's a certain moralistic tone to what she's saying here. It goes beyond administrative functionality. She is saying basically that the university was hypocritical here, or not, sorry, the NCAA was hypocritical here. One, in saying, hey, UT, you guys handled that Pruitt situation great, so much so that we recognized you for that. 6 months later, the same leadership, the same policies. Oh, that's
here's this.
That's a bad example rather than a good example. And also, she's saying that, listen, you're going after young people here and their families who they're not lawyers, and there's a lot of money on the line, and they don't know how to read these rules, but the rules are changing. Even if they do know how to read them, the rules are changing, and that's something to
Jeff,
note.
And here it creates part of the legal ambiguity is, one of the things that was touched upon by Chancellor Plowman and the dueling statements, when the Supreme Court in Austin ruled that amateur athletes were getting exploited and it was an antitrust violation, they deferred to state law. Before we could ever have a collective here in the state of Tennessee, the legislature had to pass a bill, a law, to okay collectives and NIL, et cetera. So the other thing that's at issue here is what was California law at the time the collective signed NICO. But here is the legal intellectual fallacy. You don't want to have a NIL collective and you raise the money through the University of Tennessee, University of Alabama, University of Florida. You want to use it to pay athletes to come to your university. And when they're here, they have a third party, a collective that signs and manages the agreement. But to say that there's a complete disconnect between recruiting the athlete and the money coming from boosters is just absurd. It's pretextual, and I think this litigation, and I think it will probably keep going, so we're going to be in the district court here in the Eastern District of Tennessee. Then I think it's going to go to the Sixth Circuit Court of Appeals. Then I think the Supreme Court is going to hear this again, and it'll be interesting how the Virginia case parallels our case and how quick it'll be heard.
And these are not even the only cases. The Justice Department and 10 states, including Tennessee, have a separate similar case connected with whether or not student athletes can transfer more than once in their career. And that's another point that they're making about antitrust is you're the NCAA, you are effectively the only game in town when it comes to big-time college athletics. If you've got a rule that says, I can't transfer from this college that's going to mean more money for me, right? Whether or not it's coming from the college, or to that one that's going to pay still more, you're limiting my earnings, and that's not something you can do if you're the only game in town.
Yeah, Jeff, that's a great point. When you have the transfer portal, which is now wide open, and then someone, let's say, leaves the University of Tennessee and then goes to the University of Alabama, you can't tell me that there's not a discussion of will my NIL money be the same, less, or greater. And if that conversation did in fact happen under the NCAA rules, regulations du jour, rules of the moment, it's a violation, and you only have to prove it, Lori, circumstantially.
Interesting.
Like a text that says, how much am I going to make? Is that enough?
Right.
And so, they have set up these legal layers of protection, collectives. I mean, you can go to a UT basketball game and you see the name of our collective there, at Thompson Bowling Arena. But, this federal judge is going to really have to when Pandora's box was open, the court now has to put Pandora back in.
Talk about chaos. All
So
right,
what happens? So what happens, Greg? As we're leaving you,
you're saying it may go to the Supreme Court,
or I mean, does the NCAA have to completely overhaul itself?
If they're going to pursue sanctions against the University of Tennessee in this case, then NIL is dead for the moment. And then there are a bunch of boosters and a bunch of collectives and a bunch of athletes that have relied upon money that are going to be not happy. A lot of families are not going to be happy. A lot of student athletes that have relied to their detriment are going to be hurt. So This is bigger than just Rocky Top getting a slap
Right.
on the wrist.
All right, let's talk more about this at 5:30, shall we?
Let's
We're
do
going to
it.
be talking about this for a long time. Thanks for being with us today. Jeff, thank you for being
Thank
with
you.
us.
Thank you for having me.
Our executive producer. Glad you're with us today.
Good job, Jeffrey.